right, good afternoon, everybody, and welcome to the Board of Health meeting. Today, April 4th, 2023, and with that, I'm going to turn it over to our Director of Public Health, Ms. Locke. So, go ahead.
Good afternoon. Let's do introductions. Start with you, Laurel.
Laurel Schaefer, Assistant Director.
Bobby Locke, Director.
Kent Lindsay, Commissioner.
Jim Candelaria, Commissioner.
Gerald Copenhaver, Commissioner.
Ian McLaren, County Attorney.
Tim Ruiz-Brown, Emergency Preparedness and Response Coordinator and Septic Person in Training.
Melissa Matthews, Septic Inspector.
Okay. So we have a lot of folks here, and what we're going to talk about, well, first of all, everybody good with the minutes from the last meeting?
Yes.
Any changes? No? Okay, good. All right, thank you. And our whole meeting was geared around the on-site waste treatment systems and the topic of non-compliant homeowners. So basically, we had 3 outstanding that we know of. I think we're down to 2 right now. So I think Melissa and I had talked a little bit about how we want to frame this conversation. I would suggest we take one case, one property at a time, talk about it, whatever history we have on it, how we've tried to address it through the mail service with certified mail, and how we want to move forward with how to address each one of those things.
And so I'm going to jump in here.
Absolutely.
Because I think what we're dealing with, I understand there's these 3 non-compliant properties. It sounds like now there's 2. And under the statute, what's contemplated is that the Board of Health can have a hearing and can assess whether a violation has occurred of Regulation 3043 and then of state statute. If you guys find that a violation has occurred, then the violator can be fined up to $50 a day. My understanding is that registered mail return receipt requested with a notice of today's hearing was sent to the property owners,
Correct.
but that we did not receive return receipts back from.
We did today. They just came back today.
Oh, okay.
Yeah, 2 of them. Oh, actually, sorry, 3 of them. All 3 of them have come back.
But had they signed them?
No, none of them have been signed.
And so that's our issue. Without a signature, there's no indication that those notices have been picked up and received. Now, the issue for us with that is that we have no proof that those violators received any notice of today's hearing or hearings if they were to occur. There's nothing in the state statute or in Regulation 43 that specifically requires that violators be present. But what I would say is that if you look at any sort of similar hearing across the board or court hearing or anything else, notice is a huge part of due process in the law, and being notified of a hearing is super important. My recommendation to the board would be, before we have any hearings regarding violations, that we make sure that we have proof that those property owners have received notice of the hearing. My recommendation would also be not to talk about specific facts of the properties that are in violation until we have the hearing, because similar to the way we deal with land use issues, you guys sit as a quasi-judicial body. And so to receive information about the properties prior to the hearing really wouldn't be proper, since ultimately you guys are going to sit as the judges. Now, we've talked a little bit and kind of exchanged a couple emails about the ways that I would recommend we get service done. My recommendation would be that if we don't have success getting return receipts with a signature indicating receipt of the notices, that we have a process server serve the notices to the violators. Now, obviously, there's a cost involved with that, and I know that the health department had reached out to me and asked whether or not we could recoup those fees from the landowners that were served. And I mean, generally, process servers range anywhere from $40 to $60. That's usually what a private process server will charge. I think the sheriff generally charges similar rates. That's what I've seen in child protection and civil cases. There's not really a mechanism in Regulation 43 or for this kind of hearing to recoup that fee. Now, if it was a civil case in front of the district court or the county court, you could ask for court costs and fees, and then the judge would go through an evaluation and sometimes award those. Generally speaking, costs for service of process aren't going to be awarded. And it's just a cost that a plaintiff generally bears when they initiate any kind of legal action, be it a civil action or criminal action or a dependency neglect action. What I explained to Bobby earlier today is, for instance, in a child protection case, before the court obtains jurisdiction over that parent, we have to have a copy of that complaint served on the parent, and that's what gives the court jurisdiction to proceed. Now, we don't recoup those costs. That's just something that we as a plaintiff bears. Now, that's not to say that, if this commission were to, for instance, choose to assess a fine of $50 a day, you guys could certainly put that into a fund that would be, or into a budget item. I mean, it would really go back into the general fund, but then, or into the social service or the health department budget. But I mean, that's not to say that money couldn't be set aside in a budget to account for process service fees or fees related to these hearings. But I'd be really uncomfortable moving forward with a hearing on a non-compliant septic plant without clear proof that that property owner had gotten notice that that hearing was going to happen.
So let me ask a question, and I'll put it to you, Melissa. So anybody can avoid signing that. Just because it's sent doesn't mean they ever have to sign it, correct? So if we go about serving them, I mean, to me, to you, I mean, to bear a $60 cost to make sure that they're served doesn't seem like that big of an issue. Is it, or is it not?
Well, I think it's a cost that we wouldn't typically have
Right.
if
Right.
people had followed the rules. So personally, as the department head, I think we should be able to recoup those costs from the individual. But I understand what Ian is saying. So, I'm not an attorney, so I can't. But to me, as the department head, I would like to get that money back, because I think that that's an expense that we've incurred because people
Right.
haven't done what's expected. And the majority of people in our county have. So I think that it should be relayed to that person to reimburse us. But I guess what you just said is a big question for me, because even to have a server come and serve you papers, people avoid those servers all the time.
They do.
So where do you go at that point?
And that was.
You have to, there are alternate terms of service, but you can get people served. It's pretty hard to jump service for an extended period of time. And people do successfully do it, but generally speaking, I mean, since I've been here, I can't think of anybody who's managed to successfully avoid service.
So every time that server makes an attempt, is that $60 every time they make an attempt to somebody?
That's something that you got to negotiate with the process server, and it kind of varies.
So I guess my question is, if previous attempts have been made for collection, whether it was another certified letter, and those were signed for, same property, same person, and now we've come to the point where they still are not being compliant, you cannot argue that they haven't been notified.
The point is they have to be notified of the hearing. They should be notified of the hearing.
Okay. And so in this case, again, we're not child services. Is this a civil matter or is this a criminal matter?
This is a matter before this quasi-judicial body, so it's neither. It's
Okay.
not in the court system
So
yet.
it's, we're acting, the public hearing is to us, and what do? Once we hear the information, just like Ian explained it. So
And
I
I
get
think-
that, it's just a matter of
Well, and I think another piece of this is, I mean, there's pretty wide discretion in terms of how you guys want to act in terms of assessing fines. I mean, conceivably, you could have somebody come before you for a public hearing. One option might be to listen to the evidence, to make a finding, and then to delay imposing a fine for a few months. The other option may be to start a fine right then. And so, you know, in terms of looking at how you're going to impose a fine or how much of a fine you're going to impose, are you going to impose $20 a day, you're going to impose up to the $50 a day that you can. I mean, those might be things that you weigh. I mean, things such as what kind of costs has the county incurred in trying to track down the violator. That might be something that you could consider in assessing how to impose a fine.
But then how do we collect the fine?
Well, the fine ultimately would be collected, if they didn't pay, then it could be collected through asking the court to enter a judgment, and then, once the judgment's entered, it could conceivably be attached onto property as a lien.
So then,
So, so we shouldn't discuss the case.
I wouldn't discuss facts of any individual cases
of any
today
individual
that
case,
you're
but
gonna
we
hear.
could still have a conversation in general, is what you're saying.
I think that's what we're doing right now.
Right. In general, broad terms, until we actually get these people or properties, and then we move forward with that type of a public hearing at that point in time.
And again, I want to be really clear. There's nothing in the regulation or in state statute that requires a violator to be present at the hearing. That said,
So,
I think that it's a very good idea to be sure that at the very least they had notice, because I think it raises a due process issue. And I think it's an issue that the courts, in the event that we went to get a judgment entered, or if we ever ended up in district court to pursue a violator further, that's a question the courts are going to be very curious about. Did the individual have notice of the hearing in front of the quasi-judicial body? Courts are big on notice. Due process is a big deal. And so that's why my suggestion would be, best practices is to absolutely have some kind of piece of paper, whether it's something that's signed that said, hey, we got the notice, or a paper from a process server that said, hey, we handed the notice to this violator. And then we know. Then there's no argument that, hey, we didn't know, we weren't aware of the hearing.
and then we can continue on with our public hearing, whether they're here or not.
Absolutely.
Because they've been notified.
Absolutely. If they're notified, there's no issue with moving forward. We absolutely could and should. I mean, and that's pretty standard in the courts and in any kind of judicial proceeding. I mean, if you get notice and you're not there, then you're sort of at the mercy of the judge or the quasi-judicial body or whoever it is you're having to answer to.
So I just, I totally understand what you're saying, Ian. I just want to, just for clarification, the individuals are aware that an attempt to serve them a letter, they got notice of that and did not go collect at the post office to find out what the letter is. So, I mean, they don't know what the letter says, obviously, because it hasn't been opened, right? So, but they do know that somebody's trying to reach them. So, just so you all know that that did happen, and no movement on their part, so.
Did you say that you sent them a letter before?
Oh, yeah.
That has not been returned.
Correct. And I actually had to sign
So I guess my question is,
This sort of thing is not unusual. I mean, when you look in terms of child support court, I mean, there's a lot of times folks who are obligated to pay child support know that they're obligated to pay child support. They know the child support unit's trying to get in touch with them. They get letters but it really is, I mean, when
Right.
you get served with that summons, that's when you come and answer to the man.
Well, and historically, I've not had this happen very, very often. I mean, usually people will get the first certified letter and make an attempt, you know, or, but I haven't had a phone call, not an email, nothing.
Well, and-
It's bizarre.
And I mean, and I have no idea what these cases involve, but you might be dealing with some situations where people are living in sort of off-the-grid type environments. And sometimes people who live in off-the-grid type of environments don't collect mail or answer to mail the same way that maybe you or I would. I don't know. I don't know if that's the situation. It's just a thought.
So then, it sounds like we won't continue on with the public hearing today, on this property because we haven't, not physically, we have not tried to reach out, we know that someone trying to get ahold of them, it's just a matter of that.
The health department is trying to get a hold of them, too. I mean, it's on the,
So then let's move to the next step.
Hold on.
Which is the
Yeah.
processing.
Hold on, can I ask just one quick question about mail service? So, as far as, sending notification of any, not necessarily a hearing, do I have to provide, 3 attempts, or can I go straight to, okay, you have, clearly avoided, a phone call or an email? Can I send a process server with, this is your last, like, instead of spending money on certified mail and having no luck that way, can I just automatically send?
Absolutely.
Okay.
The point is that we just want to make sure we have proof that they get their notice. And I mean, however that happens, I mean, you can do a process server right out of the gate. And, yep. Nope. Nope. And one other thing that I would just mention, I mean, just for scheduling purposes, I mean, I know we generally don't have these Board of Health meetings on a regular basis, quarterly, right?
right.
And so, you could schedule public hearings at our quarterly Board of Health meeting, or, I mean, these meetings can be scheduled any time.
Right.
The Board
Right.
of Health can convene
Right.
We are
next
more than
month
happy
if you
to-
guys want to.
Right, and what we historically did, prior to having actual Board of Health meetings like this, it would be the commission, and when we had to bring something in front of the commission, and they had to act as a Board of Health, they would exit the commission, re-enter as the Board of Health, it's still the same process, but it's removing you as the commission, and now you're the Board of Health making these decisions. So, because it does typically have to be done by the Board of Health, these decisions. So, we can totally fit that in. We can just get Travis to put us on an agenda and do it at a BOCC meeting and just have you enter into the Board of Health meeting,
Right afterwards, because with our workshops now, we're usually done at noon.
Right.
So we can always, it doesn't
Gotcha.
have to be quarterly, it could be next week if you're successful. If
Right,
you do that
right.
quick. Or
I would
2
just-
weeks, 3 weeks, I mean, whatever it is, it doesn't, we can meet anytime. We just have to publicly notice and
Right.
go through that.
I would just suggest that we leave some time for these things, because these kind of public hearings, I mean, I want to be sure that we have time to
Sure.
give you an opportunity to present everything that you know, and then, if a landowner's there, they need to be able to present, I mean, in the same
Right.
way you would present in a court of law, because that's kind of what this is. This is a court, similar to a court hearing, and this board is the judge.
So I have a question, Ian, in regards to best strategy, using a server versus using the sheriff. Is there a recommendation, best practice?
I would suggest using a private process server, and I can get you the names of some process servers that we use down in our office.
Yeah. Okay.
I know at times the sheriff's office has been a little bit reluctant to serve documents if there's not a pending complaint in court. And so that's certainly one element. The other thing I would say is, in my experience, I mean, the sheriff's deputies are really busy. They have a lot going on.
Exactly, yeah.
Some of the private process servers, I mean, really what keeps them in business is successful service. And so there might be some, in some cases, more motivation to get that. And I'm not knocking
Right.
what the sheriff
Right.
does.
No.
It's just sort of,
And I think we would ask that question of whatever process server we use as far as, are you gonna charge us $60 every time you make a trip to the house? Do you know what I mean? And how many times do you do that? Or do we get so many visits within that $60 rate? I mean, so that's something we would talk to them about, correct?
And so, yep. And so the
Okay.
general, the rule for service a process is you have to have somebody who's over, I'd have to look at the rule if it's 18 or 21. It's one of those two. I think it's 18, over 18, who's not associated with the case or with any of the bodies involved in the case. So, conceivably, I could go out on the street and wait until somebody passes and say, hey, would you be willing to serve process on so-and-so for me? And then hand them the documents and they go and serve process. So, it's a pretty broad range. Now, there are people who do this as a job on a regular basis, and that's who you want to use. The other piece is you don't want to use somebody who doesn't know what they're doing and get them into a sticky situation. Not everybody loves to see a process server show up.
I think that would be my concern also, is we've been put on an agenda because we have to provide notice. So let's just say it's a month from now, we hire a process server and they're still not able to serve before the hearing. I guess that would be my concern too.
We could schedule the public hearing after we know they've been served.
Yeah.
Because
But we have to notify them of the date. We would have to notify them of the date that they would have to appear.
And that happens all the time. I can tell you, I've sat through child support dockets where we had, 8 or 9 hearings set at 9 o'clock, and 3 or 4 of them, we weren't able to obtain service. And we would continue the hearing till the next month to get service. It's not,
So why don't we just set, if this is okay with you guys, set it out for another 4 weeks, gives you enough time to hopefully get them served, and then we go again. We don't have to wait for a quarter meeting. That would be-
Yeah, and we have her on a limited basis.
You were the one making the schedule, so that was just a suggestion.
We'll figure it out.
So,
Stay within the white line somewhere.
so thinking about the scenario you were just talking about, Ian, I'm going back to the cost of things, right? So we schedule the hearing, the person, the server wasn't successful. But, when there's been time spent, manpower spent, prepping spent, and then, the person was never served properly, is all of that recoupable? Is that even a word? I don't know. Recoupable. I'm making this up.
no, it's
There you
not-
go. I liked recoupable.
It's not recoupable in terms of you can't recoup it in terms of saying, hey, we spent this much money and this is what we're recouping from you.
Okay.
This board can impose a $50 a day fine for every day that they're out of compliance.
And that,
I see it in 4 of us.
would start from the hearing, right? Yes.
So I think technically you could start it from however long you could prove that they were out of compliance. You could
you can go back
you could
to
impose
them.
retroactive. I wouldn't suggest that this board do that. But
But
You
at the
could.
public hearing, whatever day, you definitely move from that day forward.
Right.
And that
Right.
would be a recoverable cost to you out of that, when that fee is put into that.
here's
Well, and
here's
that can
the
be part of the conversation, right, at the hearing when Melissa's, I don't want to say pleading her case, but, describing the history, like how long this has been going on, when the first attempts were, like you want to know all that, correct? That's all part of the picture.
Yeah, and really though, what's relevant is whether the system's out of compliance or in compliance. And if it's out of compliance, how long is it going to take somebody to get a system into compliance? If this board is worried about recouping a service fee, that's going to happen pretty quick. I mean, you're not going to have a public hearing and have somebody go out and get a septic system installed the next day.
Well, this is not talking about functioning or existing systems that are non-functioning. This is, they've put in a brand-new system and they have just not paid fees. And some of them are road impact fees that the planning department
Well,
does too.
so, I mean, again, the findings. The big point is that we get people into compliance.
So,
And,
right.
and it might
What
cost
she's
a
saying
little
is they're
bit.
circumventing the entire process,
Yep.
everything. They're living there, it's installed, but the whole process is circumvented, which is not fair to anybody else in this county. Correct.
Well, that's why we have the hearing and.
So, this is just one man's opinion, is get them served immediately, and we move forward. Set the date, schedule it, what works for you, and let's rock and roll. Because it's not fair to the rest of the county that's doing it right. And then we've done our due process, we've had them served, and if they choose to be here or not, then that's their choice.
Yeah, I think that's what I would suggest.
And you may not get your recouped costs or recovered. That's just, that's just, I feel that's probably.
Okay, I do have another question. I apologize. And correct me if I'm wrong, Ian. So if we have our hearing, there's a judgment, whether it's $50 a day out of compliance, whatever, and there is, so there is a judgment and they have to pay a certain amount. Is there then a time frame that they would have to become compliant with that? Is that written into statute or anything?
Not that I'm aware of, but I mean, generally that would be similar to any other debt that's not paid. I mean, you could conceivably go to the court and get a judgment entered. I mean, I would certainly give people a reasonable time to pay.
Right, but, so I guess my next step would be they choose not to pay that fee. And then I think we had talked about the potential for a lien on the property. Is that correct?
Well, so the first step would be to get a judgment entered,
Okay,
and that would be done by the court. And then
Okay.
once the judgment's entered, then you go through another process to attach it to the property. It's cumbersome.
It
Hopefully
is.
we don't get that far.
exactly. I'm just thinking again about cost of providing the program, cost of, everything, and how, anyway, just because we bring them in front of the Board of Health and they still choose not to pay, I don't know, I'm just curious.
So I guess now I'm asking a question now. So how does this differ from what we do with our noxious weed program? So we send out letters, we send out certified letters, and then it's brought to us to cross the property to go ahead and
Yep.
get those taken care of per statute, just like this is per statute, and we don't have a public hearing on that.
The noxious weed statutes are different. It's a different statutory scheme.
Okay.
They've been scheming on you.
Yeah.
Well, I mean, you look across enforcement procedures across all sorts of different areas of the law. I mean, there's always, the statutes allow for enforcement all different ways, and this just happens to say this is how you do it. Noxious weed, at some point, somebody got a law passed that allowed the counties to circumvent the court process and place automatic liens. I mean, that's just the law. And there's not a similar law for septic.
Okay. So, clear as mud.
Do you have any questions? I mean, I know this is brand-new stuff
So
for you.
I do have a question.
Oh, sure.
So how long has this been going on?
Those are
Can-
specifics
I
of
mean,
the,
I mean, just
I
in
think in
generality,
general,
I'm
I
not,
think,
I'm not.
yeah.
Okay, since 2020.
So I think at some point, we need to make some type of regulation that says, if they go on for this long, we are gonna send them processed. We're not gonna mess around. Don't let them go for 3 years. Okay? I mean, to me, we need to basically make some rules about how we're gonna do this in the future.
And that would be interdepartmental is what I would think. And I would agree with you too, 3 years is.
I mean, let's figure out what we're gonna do here and not continue this process, because if people out there know that we're not gonna mess around with them, that we're gonna do this, it will stop a lot of it just by the fact that people, word of mouth goes a long ways.
It's a really good idea, and we could, I have never developed a policy like that, but we could reach out to other LPHAs and find out, get some samples, get with Ian's help on how to compose such a document. But I agree. I think it's not okay for the rest of the community who is following the rules to allow that. And so now we're, kind of trying to play catch up, and it's.
So, just so I understand how this works in real life, without talking about a specific case, I mean, in general, the process would be they come in and apply for a permit and then just never pay, or they never come in? I mean, how do we find the violation? What does that look like on the ground?
So the proper procedure is an individual wanting to develop in Montezuma County has to go to the online portal and start a property contact form. That alerts the planning department, the GIS or addressing, and the health department. Also driveway, the road and bridge. So that will navigate people to the correct departments on what needs to be completed. Then it's up to us to contact the individual to define what the process is. As an example, what you need to do for a septic permit. A lot of people, again, word of mouth, past years, most everybody already knows that all systems have to be engineered now. That's just like a common thing. People just know that that's what they need to do. So, so they've typically already made that call. They've already had an engineer come out to their property. But on that online portal, they can even submit their engineering, and then we are able to review that. The disadvantage is none of our departments can accept payment through that portal. So again, we as Board of Health or Health Department are completely different budget-wise than the other part of the county. So I understand that might be a hurdle to cross. But the way that we found out about some of the issues in the past, I'll just say other systems, complaints by neighbors. An engineer submitted the information, but then the homeowner, the property owner, has never made contact. A final certification letter has been submitted sometimes from the engineer, but no design, no application has been submitted. So, I mean, there's several ways that we have become familiar with some of these properties.
Okay.
This seems like super simple though. I mean, they're basically out of compliance for just non-payment or.
Yeah, everything else has been
I
great.
mean, if an engineer's been checked off
Yeah.
and it's all done.
And it's
functioning
installed and it's been
properly,
inspected, yeah.
it's super simple.
Yeah.
Why would they be dodging it? I mean, doesn't seem real logical, but.
And our fees are still relatively low as opposed to the rest of the state. So I don't understand it either.
So then, you will develop some process within your department to move these forward so that we don't allow 3 years because that's too long.
Right. So I guess that was kind of where my question was going. As far as like what Commissioner Copenhaver was saying, do we have to develop that within our own regulation? Because we do have an appendix to Regulation 43. Is that something we would have to go back through the public hearing process and develop that into our own regulations? Or is that something departmental line?
So I think about it more on a departmental basis. I mean, the tricky thing with coming up with some of this stuff is, I mean, it sounds like there's all different ways that these come before you. And so, I mean, there may be situations where something's been in the ground for 4 years and a neighbor reaches out. But I mean, I think it's pretty simple. I mean, I think once you guys, I mean, it's as simple as once you guys learn of the violation, set some number of days. I mean, I don't know what's reasonable, 60 days, 30 days, 10 days. I mean, you figure it out and then just do it. I mean, if it's, once you hit that timeline, if you don't have a result, then you send out the process server, you send out the certified letter, and away we go.
Does that sound like, Commissioner Copenhaver, would that meet what you're asking for? If we had something, like we said, that once we are made aware of this homeowner that has an unpaid septic system, the clock starts, and we've notified them, obviously. So do we give it like a 60-day or 30-day, what?
Personally, I think if you notify somebody that they're out of compliance and they need to pay this bill, you give them 30 days. If they don't pay that bill in that time, after that 30 days, I would serve them.
Okay.
I'm messing with them.
I mean, that's what I'm after,
I
is
mean, to
something
me-
defined that we can,
I don't know, maybe
Look
the
at that.
time needs, does time need to be longer than that? I just
I
don't.
mean, I think if you're out of compliance, you're out of compliance. And
That's what
I
I
mean,
mean.
it's kind of like if I don't pay my water bill or my electric bill, I mean, I get a certain amount of time and they come and shut me off. I mean, that's just kind of the way, the way it works. So.
to me, that seems a little simpler. It's not a policy per se, it's just it's a procedure, you know?
It's a process
That,
of
right.
how to handle these cases. And just, I would get them notice that they're out of compliance, and if they don't comply within 30 days of paying the bill, I would
Then you
start
get
the
a server.
process. Don't mess with them.
Okay. So would we, this is what happens, my brain just starts thinking this thing. So should we post that on our, like on our OWTS, part of our website, this new rule? Or
think it's any
do
new-
we
I don't-
just do it?
I don't
and-
think there's any new rule.
Okay.
I think it's just
We've got some
Correct.
you guys are
guidance
just
moving
doing what you
forward.
can
You're
do.
just doing your
Right.
job.
Yep.
You're
Okay.
just saying, this is how we're going to move forward.
Okay,
It's not a
Okay.
new rule.
all right. I like it because I don't like talking about things that are from 2020 in 2023.
I don't either.
So,
2020 never
um,
happened.
Well, if it's any consolation, I wouldn't find out about it until 2022.
Yeah, well, that doesn't really make me feel better.
And the reality is there's probably a lot of septic systems around Montezuma County that aren't engineered. I mean, there's,
Well, I don't think that, it's just out of
that were
compliance,
there,
just for the,
before, like,
just for the fee.
I forget when we did that.
They've been
2006 or
engineered, they've been
I believe
checked
they
off.
actually engineered a system for that.
know about.
Yeah,
We
no,
designed them,
sure.
More out there,
which was a terrible deal.
but now we
If we know that once we are tipped off that there's something out there that we need to address, we address it, we give it 30 days, we serve them papers, get it on the,
Yep.
on the agenda and move forward. So, yeah, okay, I'm good with it. How about you?
I will now start putting the fee, like the fact that they can't be subject to $50 fine for every day out of compliance. I think that will probably have a lot of impact as well. I don't think people realize that is a statute.
definitely, I think we bypass the certified mail and we just do the server. Right. It's a waste of money, and how long did it take till we finally get that back today, and you sent that, what? So, you know, that's how long the process took to get not even an answer, you know, really, because all we have is a letter that was sent back to us that nobody read. That's what we have, so we wasted a
You're
month.
not that far behind, because I got a letter from the state of Utah the other day, just like that, that I owed $58 for buying trichomoniasis tags for the bulls, and that I hadn't paid the bill. Well, we had a check where we had paid the bill from back at, but they have never noticed us since 2000, and I think it was 18 or 19 when that happened. And I don't know how many, I mean, I buy 200 or 300 trick tags from them a year ever since then. They've never ever said anything this whole time. But my wife went back and she had paid the bill. So,
Well, we only have one, I believe, that's from that year, the 2020. The others are from last year, the end of last year.
Tim, does that seem clear to you? Because, I mean, you're gonna be taking this ball and running down the hill with it, you know, moving forward.
I guess and Ian kind of got into it a little bit, is how many of them are out there? How far back do you go? Like, you know, it seems like we started permitting in 1974. So if there's only been one homeowner an entire time, like they constructed the home and the septic system in 1975, what do you do? I mean, do you technically have the authority to start the fine process in 1975, you know? Like, I mean, I know you practically you wouldn't do that, but it's just like, what's the cutoff and et cetera? You know, that's where my head goes.
Going along that line, so since our county started doing the engineered systems in 2004, if the property owner is able to come to you with a design and even pictures, then you can do an after-the-fact permit. But definitely systems prior to that, you know, even the permits we have may not have an accurate diagram of the system, or a big X through it and then, you know, another arrow showing something else. And so again, that's going to be your personal judgment on how you want to handle that. You could request an inspection to be completed on that system by one of those NAWT inspectors. They could verify what was there. I mean, again, my philosophy has always been, don't just charge a permit fee to charge a permit fee. It's important to know what is on that property, what kind of a system is, I mean, that to me is more important than just charging a permit fee.
Setting kind of a precedence though, you know, if we do this to one person, I guess that's where, I don't know.
What do you mean,
As far
these?
as, like this quasi hearing. Like I just, that's where my,
I think we can have a public hearing anytime you have a violation. So it's really with any violation, after they've been notified and then we can take them.
because before we went to those engineered systems, the county actually designed most of the systems for people. If people come in to get a permit, the county, our county person would actually design a system for them. That's the way it was done before. And we basically got out of that because we felt like we were putting ourselves at risk by designing the systems if it failed. So we went to the engineered system, plus we were looking at the houses being closer and closer together and in the future. So that's what happened over time. A lot of those systems that were put in back then, which I have two of them, I guess, one down here and one in Mancus. They've never failed. I've never had any problem with either one of them, but, you know, there's a lot of them around.
Yeah, be checking them since we've had so much water this year.
Yeah.
Be checking them.
Any other questions, you guys? Okay. Yeah, I think it definitely is helpful. It gives us guidance. We have a 30-day, I mean, I feel like that's a solid window of time. And, you know, then people don't do what they're supposed to do, then we serve them. We'll get a server lined up. We'll talk with Ian for some names. We're gonna get on that ASAP on the ones that we currently have. And then, once we know they've been served, we'll get ourselves on the BOCC and we'll let Travis know that it's the Board of Health OWTS. Okay? We'll move it along as quick as we can for these historical ones. Right. 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 Okay. Got it. Okay. Well, this was a good discussion. I know we didn't do what we intended to come here today, but the discussion was very helpful, and I think this gives us a definite guide moving forward. So, good. Anything else you can think of? Uh-oh.
I'm on the suggestion for the next.
Oh, for the next agenda. Okay.
You're already
Okay.
moving on.
I have to.
Okay.
It kind of pertains to what we're talking about in some regards.
Okay. Well, I think we can close the conversation on the non-compliant OWTS for now, and then what else were you going to say? For
So talking about potential systems in failure, I don't know if there are counties that have acquired special, like grant funding for properties that might need help in funding failing septic systems. It just might be something, I don't know, I don't even know how to go about inquiring about that, but, because currently, there is the Housing Solutions in Durango that, I think they're like a 1% loan maybe, for, and that doesn't necessarily just apply to septic systems. It could be, your roof is leaking, or, you need new windows or whatever in your home. And then there's.
Or a weatherization, right? Right.
Yeah. Anyway, I don't know if you have heard of any other, because again, you deal with other counties that's ever even been talked about.
As far as,
Like if there are.
like a
any
loan, a
grants or
grant,
anything like that.
not.
Where the county would maybe oversee that.
That's an individualized person, and grants typically don't go to individualized people. They go to, governmental agencies or, but not that I've heard.
Right, okay.
Nothing that I've heard, so. But I guess what, the question is, if somebody has a failing system,
It's up to them to obtain the funding, obviously, to fix it.
well, yeah, there's banks we have banks everywhere that,
But I don't know if they loan on something like that.
well, they loan it on the property.
Not a tangible necessarily.
It's tangible to the house.
Do
I
they
would,
loan on, like, if you're in the city with a repair of a line, though? From the city to your house? I don't know if it's kind of the same concept.
I'm not a banker,
I
but
don't know, I was just curious if with your meetings with the commissioners, if.
that's never come up. That has never come up. It's usually up to the individual homeowner, to seek whatever kind of funding they
I think
can.
most of them end up refinancing or doing something like that in order to come up with enough money to fix things like that.
I just,
It's about,
with our water issue this year with potential flooding, I don't know, it's gonna be interesting to see what happens with that.
McPhee Lake's gonna fill up, Ian's gonna be out skiing all the
I
time.
know, right?
Won't be any help at all.
Melissa, Housing
We could've just
Solutions
had this
might
public
be
hearing
the
then.
answer. Also, what is it, Four Corners? They do a lot of weatherization and stuff. A lot of
Well, I know
that's,
about there's a bank called Admiral Bank, that, again,
Yeah.
They specialize in septic systems, that's what they typically run their manual on, and then again, housing solutions.
Hmm.
It's something I had thought about while we were sitting here talking. Again, where you have other conversations with other commissioners in the state, I didn't know if that was even ever discussed.
In 4 years, I can tell you, I've never heard a conversation on that. Other than
Well,
that,
you can start it now.
other than that, I can't,
Yeah, I don't.
but I can say in 4 years,
Okay.
Keep our eye out.
it might be a good conversation to have with some bankers. I mean, because if people know that they can go to one of the local banks or all of the local banks and say, hey, I've got an issue, I don't have the money up front, because some of these obviously can be relatively spendy to fix.
Right. Oh, absolutely. Getting worse and worse. That was it. That's all I had on.
Okay.
So is that a conversation item for next Board of Health? Is that where
No.
you're at, or
No,
you
I
were still
just-
backing up to the other,
Yeah,
or you were in between?
I was in between. Yeah. I was on the in-between. Okay.
You were in the gray.
Okay.
Sounded to me like she was in this, well,
Yeah.
be quiet.
Okay, well, our meeting was all about OWTS today, so I don't necessarily have anything else to talk about unless any of you guys have anything you want to discuss from a public health perspective.
You want to talk about masks? You want to jump on the mask bandwagon?
No, I'm gonna not. Go ahead, jump on something, and then I'll follow up. I think, OWTS is a big thing in this county because we still have so many, people out there that obviously utilize this type of a system. And it's critical that we, we take these to task, kind of like Commissioner Copenhaver said, let's quit. If we're gonna do it, let's get this done, because then everybody is on the same page. And the people that are not doing it, they're just circumventing the whole system, so 100% agree with that. Now I'm moving on to suggestions for the next meeting. What do you have? What are your recommendations? What do you think we should talk about?
I think we should get these people served and have a hearing.
We're on that.
And
we even need to do it before July. We definitely want to get it handled before July.
But I mean, the end of the public health emergency is coming up, so. But July will be way after the fact.
Pest. The emergency will be over. I had a thought. and it left. Oh, well, we can give you a little bit of an update of where we are with our fentanyl test strip program by then, because we have gotten trained and we're in the process of launching it in this next week. So we can kind of report out how that's going, who we've partnered with and who we're working with, and how well received or not well received it's been. So we can fill you in on that, because we'll be 3 months into it by then. Can you think of anything in particular?
On the Narcan giveaway,
Mm-hmm.
do you ever get any knowledge of results? People call you up, say, we used this?
I haven't gotten that yet.
Okay.
But we have given, I think we've given a lot out to community partners.
Right.
We are attaching Narcan along with all fentanyl test strips, so people will get the Narcan as well with those. So I haven't gotten specifics as far as somebody saying that they've used it and it saved a life. I have not gotten that specific yet, so.
Bobby, do
Yeah.
you know, I mean, I've heard this, but I'm not sure that this is the way it is, but where they're mixing that xylazine with the fentanyl, is it blocking your test strips?
It
What's
depends on
what's it
how
doing?
much, yeah,
I mean, that's what I heard.
right.
Why
And
they were doing that.
yeah, and when we were having our presentation the other day, according to the officer that was there, so far, it hasn't been detected locally here in our area, or in the state of Colorado, I've heard, but it's right nearby. So it's only a matter of time till it is detected here. So, it's a neighboring state. So I do think that, but they said that when that is mixed in, it, like, the Narcan doesn't necessarily help either. So I don't know what
So the
that's going to
Narcan
do
don't
to the,
work either.
that's what do you remember them saying that, Tim? Yeah. So, because it blocks the receptors, and I should have brought my notes, but it doesn't, it's not going to help in that, but they still say to try it, because maybe there isn't the xylazine in there, you know what I mean? So it might, you don't want to ever not administer it, because you might be able to save a life. So, but they're seeing that people aren't responding, like they don't respond near as quickly, even after a second dose of Narcan. They're not waking up like you typically would. So,
The term zombie's been thrown out.
so it really is that's a pretty dangerous deal. So I don't know what that would do to a test strip. I don't think Sophie really said. She mentioned the xylazine when she gave us our training, but I don't remember.
See, I heard that was actually blocking the test strips.
It would make
The
sense
test
that it
where
would.
the test strip
It-
when it was mixed with xylazine, and that's why they were doing it. I don't know. That's why I was wondering if you had heard anything about that.
I don't know, and she did not cover that in the training, but she did mention the xylazine and how potent it is, and that's why it's really I'm hoping it waits a while till it gets here, but I don't know. It's probably not going to. So, yeah, I think as we use them, we will get as much feedback as we can from folks who are using the test strips, and it's very simple to actually use them. And we're going to be giving them out we're formulating education packets to go with 10 test strips and 1 box, which is 2 vials of Narcan. They'll get all that in one fell swoop. Because historically, it takes more than 1 test strip, because people they either don't believe it, they want to test it again, or if they continue a continuous user, every hour and a half they're using, and if they've gotten supply from different buyers, they're going to want to retest their different supply. So we're giving them enough that it would hopefully help them. So anyway, I'll give you a little report of what we know, how successful it's been, and what kind of reception we're getting, in the community. So.
I would maybe just as, for the next meeting, maybe just an outline of all of the programs that you guys are running, so that it's actually aired
Sure.
just this is what we're doing at Public Health, and to make the community more aware of, we do WTF, we do test strips, I mean,
Vaccinations.
there's a big variety of things that I think the
Correct.
public really doesn't know what we do. And I think that would be more of an awareness. That's
Sure.
what I would like to see.
Sure.
Even if it's just a simple rundown of each one and you spend a minute on it.
Yeah, no, I think that's good, and it's like, all of us humans are the same. Until it's something that pertains to you or close to home, you don't necessarily pay attention to the information, right? Until it's like, oh, I need to go get my tetanus shot. Now, where do I go to do that? The health department. So it's just one of those things that we're all like that. We all put things out of our head until it hits us, so.
There's my suggestion.
Okay, it's a good suggestion. Okay, great. All right. So July 11th, it's later in the month because the first Tuesday's July 4th. So. Oh, are you going on July 11th? That I don't know. Well, we might be putting it off another week.
I'll check. Maybe
Okay.
it's towards the end of the month.
Okay. All right. Well, thank you.